considering House Resolution 918, authorizing an impeachment inquiry to examine the President of the United States. It is a deeply sad day and is an occasion I do not relish, nor, I am sure, do any of my colleagues in the room. Nonetheless, this is a weighty responsibility, one that we all take very seriously, and we must do our duty for ourselves, for the institution, and for the nation. We are here to determine a process, not an outcome. We are here to assert our Article I responsibilities, not to act as judge or jury. And we are here fundamentally to chart a path forward that unveils the facts to the public. Committees in the House have been engaged in investigating. As they continue to pursue transparency and accountability, we are formalizing their impeachment inquiry efforts to give the House the strongest legal standing to pursue needed information and enforce subpoenas. Allowing this chamber to be at the apex of its constitutional power is vital to our system of checks and balances. I will briefly summarize the procedures today's resolution establishes for the inquiry. First, it charges the Committee on Oversight and Reform, the Committee on Ways and Means, and the Committee on the Judiciary with continuing the existing inquiry. It provides procedures for conducting hearings and calling and questioning witnesses. It grants the minority equal time to question and request witnesses. It ensures investigating committees can prepare and transmit reports and documents to the Committee on the Judiciary, which traditionally considers impeachment. It gives the President and his counsel opportunities to participate in proceedings before the Committee on the Judiciary. Finally, it authorizes the Committee on the Judiciary to report to the House of Representatives resolutions, articles of impeachment, or other recommendations. If these procedures sound familiar, they should. In preparing this draft resolution, we have followed the blueprint House Democrats followed in 2019 and have drafted this resolution to closely follow House Resolution 660 from the 116th Congress. I know my friends in the minority will point out the obvious. House Republicans expressed concerns with this approach and did not support these procedures previously. How then can we support them now? The answer is, of course, that what the then majority Democrats did in 2019 is now a precedent of the House of Representatives. Having created this procedure in 2019, it's appropriate that we follow it in 2023. Before I conclude, I know today's hearing may well be a heated one. This is a difficult topic, one that sparks passions on both sides. In 2019, under the leadership of my friend, our ranking member, we were able to push through our markup with a minimum of rancor. I'm hopeful that we will again be able to do so today. Every person in this room is here because we care about this great nation of ours. Everyone is here because we believe we can make America a better place for all of our citizens. No one here, least of all myself, relishes meeting on this topic today, but I know that we will do our duty, difficult as today may be. I now yield to my very good friend, our ranking member, Mr. McGovern, for any remarks he wishes to make.
Well, thank you very much, Chairman Cole, and I just want to respond to something you said. We are not here to begin a proceeding. There's been an impeachment inquiry from day one that has been going on here, and I think it's proven time and time again that the President of the United States did absolutely nothing wrong. But this is a very, very sad day for this committee and for this institution and for this country. This impeachment sham is, to put it bluntly, an extreme political stunt. It has no credibility, no legitimacy, and no integrity. It's a distraction to draw our attention away from House Republicans' do-nothing Congress that has failed to pass any meaningful laws to help the American people. And it's a shocking weaponization of the impeachment process by MAGA extremists who are dead set on doing anything and everything they can to help elect Donald Trump. You know, when I was chairman of this committee, Donald Trump was impeached twice. Both times I took it very seriously. His first impeachment was because he tried to blackmail a foreign leader into digging up dirt on then-candidate Joe Biden. He wanted to stop Joe Biden from becoming president. His second impeachment, the most bipartisan in history, was because he tried to overturn the election by sending a violent mob here to the Capitol to stop us from certifying Joe Biden's victory as the Constitution requires us to do. He wanted to stop Biden from taking office. Thankfully, he failed. But now Republicans are back at it again, trying to hurt Joe Biden, this time by abusing and weaponizing the impeachment process itself. All of this is happening because House Republican leaders refuse to abide by the election results. They're upset Trump lost. He's upset he lost. Some of them still don't even believe he lost. Many of them are upset that the insurrection didn't succeed on January 6th. And today, they want to finish the job. And what's left in the toolbox? An impeachment stunt they want to hang around Joe Biden's neck to tarnish him as he heads into the next election. They think it will muddy the waters and confuse people who know in their gut that Trump is a criminal and Joe Biden is an honest, decent man. Let me tell Republicans right now, you will fail. Because the simple truth is your whole so-called investigation is built on a lie. Republicans began this ludicrous exercise the second they took control of this House of Representatives, the very second they took control. And it's been a big, colossal waste of time ever since. It's been a pathetic joke. Not a single witness, not a shred of evidence that says Joe Biden did anything wrong. Every single Republican allegation has been debunked and discredited and disproven. Their own legal experts say there's not enough evidence to impeach. Their blistering bombshell key witness, he turned out to be a Chinese spy. I mean, you can't make this stuff up. Their own speaker, Republican Mike Johnson, said just a few weeks ago that there's insufficient evidence to even initiate formal impeachment proceedings. Their own members, a Republican on the House Oversight Committee, was asked 2 weeks ago on Fox News, have you uncovered any wrongdoing by President Biden? She said, and I quote, the short answer is no. So Republicans have spent a year looking for dirt on Joe Biden, a year trying to make their bogus allegations stick, and at the end of it all, they have found nothing, no wrongdoing. So what is this about then? I think the answer is obvious. Republicans want to distract from their own ineffectiveness and incompetence, and they want to do everything and anything to help Donald Trump win the next election. The far-right MAGA extremists are in charge of the House of Representatives. They have neutered all the moderate Republicans and obliterated bipartisanship. And they want to cover up their own failure with this ridiculous political stunt. Donald Trump says, jump. The MAGA extremists say, how high? Donald Trump asked them to impeach Joe Biden, and here we are. They broke the law trying to stop Joe Biden from becoming president. They broke the law trying to violently overturn the election to prevent Joe Biden from taking office. And now they are waging this extreme political stunt by abusing and weaponizing the impeachment process. They tried to overturn the election on January 6th, and now they want to finish the job. And today, Democrats on the Rules Committee will make a simple case to the American people. First, that Joe Biden is a man of decency and integrity who respects the law, and this impeachment charade is an extreme political stunt designed to help Donald Trump win. Second, that every absurd Republican allegation against Joe Biden has been debunked. Third, that despite this fraudulent process, Republicans have received extraordinary cooperation from the White House. And fourth, that Republicans are doing this because they are focused on the wrong priorities and want to distract from their total failure to get anything done. And when this is all over, I am confident that the American people will overwhelmingly agree that this whole impeachment stunt is a national disgrace, designed to distract from their own incompetence and to help Donald Trump, a twice-impeached ex-president who's been indicted more times than he's been elected. I'm confident that they will see that this is about vengeance, retaliation, and distraction. Those on the far right of the Republican Party have nothing to show for their time and power. They have never accepted that Joe Biden won. Obviously, they have contempt for the American people, and they are once again trying to overturn the election. They are willing to do anything and everything to get their way. Our democracy be damned. And my so-called moderate colleagues on the other side of the aisle are unwilling or unable to say enough is enough to those who are dead set on pursuing this extreme nonsense. And with that, Mr. Chairman, I yield back.
Gentleman yields back. Pursuant to notice, I now call up House Resolution 918, directing certain committees to continue their ongoing investigation as part of the existing House of Representatives inquiry into whether sufficient grounds exist for the House of Representatives to exercise its constitutional power to impeach Joseph Biden, President of the United States of America, and for other purposes. Without objection, the resolution will be considered as read and open for amendment at any point. Is there any discussion or amendment?
Yeah, Mr. Chairman, I have an amendment at the desk.
The gentleman is recognized. Now, the clerk will report the resolutions.
Amendment number 1 to House Resolution 918, offered by Mr. McGovern.
Clerk will suspend. Without objection, the amendment is considered as read.
I object, Mr. Chair. I'd like to have the amendment read.
Clerk will report the resolution.
House Resolution 918.
Just for the purpose, does the gentleman seek recognition?
Yes, I would.
Okay. The clerk will report the amendment.
Amendment number 1 to House Resolution 918, offered by Mr. McGovern. Before the resolve clause, insert the following. Whereas President Biden began his lifetime of public service serving on the Newcastle County Council before becoming one of the youngest people ever elected to the United States Senate at age 29, whereas President Biden honorably represented Delaware for 36 years in the Senate before being elected vice president and ultimately president, where he has rebuilt our standing on the world stage and overseen the strongest job growth in American history, and whereas Donald Trump was impeached on a bipartisan basis, has been found liable for sexual abuse and for committee fraud and lying about his net worth, has been impeached twice, and is facing a total of 91 felony charges across 4 different state and federal criminal cases. Now, therefore, be it.
Mr. Chairman.
Gentleman's recognized.
Thank you, Mr. Chairman. So the purpose of this amendment is to clarify that there is no comparison between the honesty and integrity of President Joe Biden and the dishonesty and lawlessness of Donald Trump. President Biden is a decent man, an honorable man. He follows the law and cares about upholding his oath of office. President Biden has dedicated his entire career to public service, a great personal cost to himself and to his family. President Biden has rebuilt our standing on the world stage. He has overseen the strongest job growth in American history. He has passed one of the most ambitious legislative agendas I have seen during my entire time in Congress. And my Republican colleagues know this. They know Joe Biden is a good man and that Donald Trump is a criminal. So they want to put something on the other side of the scale because they know that Trump's guilty as hell. Donald Trump tried to blackmail a foreign head of state to dig up political dirt on Joe Biden. Donald Trump tried to overturn an election because he lost to Joe Biden, sending a violent mob here to the Capitol on January 6th to try to stop the certification of the election. Donald Trump's kids stole money from a cancer charity. Donald Trump's son-in-law took $2 billion from the Saudi government in a deal so shady that it would make even Richard Nixon blush. Donald Trump has been indicted more times than he's been elected. And it's clear to me why Republicans are going after Joe Biden and trying to drag his name through the mud. They want to help normalize Donald Trump's corruption and criminality. They want to convince people that everyone does it, so it doesn't matter. Well, guess what? Everyone doesn't do it, and it does matter. There's no comparison, none whatsoever, between the decency, civility, and public service of Joe Biden and the criminality, corruption, and abuse of power of Donald Trump. Republicans launched this absurd inquiry almost a year ago, and here's what we've learned. We've learned that this investigation has received extraordinary cooperation from the Biden administration and has yielded mountains of proof that all confirms President Biden follows and respects the law. We've learned that President Biden is a good dad, that he loves his son unconditionally. We've learned that his son, Hunter, lost his mom and sister in a terrible car accident. He lost his brother to cancer. This is someone with a lot of trauma in his life and who sadly turned to drugs. And we've seen that Republicans have sought to weaponize that trauma and use it to attack President Biden and his family. Frankly, it's just disgusting. I mean, we literally had Marjorie Taylor Greene hold up explicit photos of Hunter Biden at a committee hearing. And it's unclear to me whether Republicans are so full of it that they actually believe this stuff or it's all for show. But either way, I find it to be so awful and just really offensive and quite frankly rotten. And after 10 months of digging and tens of thousands of pages of documents, all Republicans have proven is that President Biden did nothing wrong. But they don't care that they've found no evidence, because for them, this is all just about weaponizing and abusing the impeachment process in order to hurt President Biden. Quote, "They did it to me." That's what Trump said in an interview a few months ago. I further quote, "And had they not done it to me, I think," and nobody officially said this, but I think had they not done it to me, perhaps you wouldn't have it being done to them, end quote. Now let that sink in. The whole impeachment stunt is happening because the former president demanded that MAGA extremists in Congress impeach Joe Biden. They don't care about the evidence. They don't care about the truth. They don't care about the damage this will do to our country or to this institution. Quote, "Either impeach the bum or fade into oblivion." That's what the former president says on social media. Either impeach the bum or fade into oblivion. So that's why we're here today. And with that, Mr. Chairman, I urge adoption of my amendment, and I yield back.
Gentleman yields back. Is there further discussion or debate on the amendment? Hearing none, the questions on the amendment. All those in favor signify by saying aye.
Aye.
Those opposed say no. No. Opinion of the chair, the noes have
I
it.
ask for a roll call.
Roll call has been requested. The clerk will call the roll.
Mr. Burgess. Mr. Burgess, no. Mr. Reschenthaler. Mr. Reschenthaler, no. Mrs. Fishbach. Mrs. Fishbach, no. Mr. Massey. Mr. Massey, no. Mr. Norman. Mr. Norman, no. Mr. Roy. Mr. Roy, no. Mrs. Houchin. Mrs. Houchin, no. Mr. Langworthy. Mr. Langworthy, no. Mr. McGovern.
Aye.
Mr. McGovern, aye. Ms. Scanlon. Aye. Ms. Scanlon, aye. Mr. Neguse. Aye. Mr. Neguse, aye. Ms. Leisure-Fernandez. Aye. Ms. Leisure-Fernandez, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 9 nays.
The noes have it. The amendment's not agreed to. There are further amendments.
Mr. Chairman, I have an amendment at the desk.
Gentlelady from New Mexico is recognized. You would,
Mr. Chair, I have an amendment at the desk.
okay. Clerk will report the amendment.
Amendment number 2 to House Resolution 918, offered by Ms. Leisure-Fernandez. Before the resolve clause, insert the following. Whereas, in the last impeachment proceedings against then-President Donald Trump, there was extensive evidence and thousands of hours of video footage of a violent attack on the Capitol that led to the deaths of 5 law enforcement officers and seriously injured more than 140 more. Whereas the violent attack on the Capitol delayed a constitutional electoral proceeding, while Trump, who incited the attack, watched it unfold for hours without intervening, according the testimony of Trump staffers before the United States House Select Committee on the January 6th attack. Whereas the evidence in the 2021 impeachment proceedings against then-President Donald Trump showed that Trump sought to overturn the election and interfere with the peaceful transfer of power for the first time in United States history. Whereas such evidence led to a bipartisan impeachment in the House, a bipartisan vote of 57 senators to convict Trump in the Senate, and a federal criminal indictment related to the January 6th assault in efforts to overturn the 2020 election. Whereas in the 11 months since the Republican-led committees, the Committee on Oversight and Accountability, the Committee on the Judiciary, and the Committee on Ways and Means first began their investigations, Republicans have received tens of thousands of pages of private bank records, Department of Treasury, the National Archives, the Federal Bureau of Investigation, and Internal Revenue Service documents, and dozens of hours of witness testimony, including Special Counsel Weiss and other high-ranking officials at the FBI, IRS, and Department of Justice attorney assigned to Hunter Biden's case. Whereas, despite the avalanche of information House Republicans received from the Biden administration, banks, and Hunter Biden's business associates, none of the 3 Republican-led House committees pursuing a Biden impeachment has found any evidence of wrongdoing by the president, let alone an impeachable offense. Whereas Senate Republicans who conducted their own investigation in 2020 of Joe Biden's conduct as vice president also did not find any evidence of wrongdoing. Whereas the evidence, including bank records and repeated statements from witnesses gathered during the current investigation, has shown that President Biden fought corruption, was not involved in his family members' business dealings, and respected the independence of the Department of Justice. Whereas the Burisma conspiracy theory that has long been debunked, and in fact the investigation has confirmed that as vice president, Joe Biden successfully led a bipartisan and international coalition urging the Ukrainian government to address corruption. Whereas President Joe Biden chose to retain David Weiss, a United States attorney appointed by Donald Trump, as the special counsel leading the Hunter Biden investigation, and it is clear that Mr. Weiss has the full authority to investigate and prosecute Hunter Biden. Whereas, while the last Trump impeachment proceedings held public hearings, House Republicans have conducted nearly all of their investigation into President Joe Biden behind closed doors, have refused to publicly release all but 2 interview transcripts, and have repeatedly misrepresented the evidence, including witnesses' statements, to falsely accuse the president of wrongdoing. Whereas, as a loving father and a brother, Joe Biden has helped members of his family in their times of need. Whereas 46,300,000 Americans aged 12 or older, or 16.5% of the United States population, had a substance use disorder in the past, and 2/3 of Americans reported they or a family member struggle with addiction. Whereas addiction significantly impacts families whose loved ones suffer from substance abuse, and whereas loving a son who has struggled with addiction and other problems is not evidence of high crimes and misdemeanors worthy of a solemn impeachment inquiry. Now for there be it.
Gentlelady is recognized to explain or address her amendment.
Mr. Chair, I offer this amendment to remind the American people that after 11 months, 3 different committees investigating and a mountain of documents and testimony, Republicans have no evidence of wrongdoing by President Joe Biden. Instead, the Republican-led investigation has proven the opposite, that this is political vengeance for the impeachment of Donald Trump. Republicans have bent over backwards to distort the truth because the twice impeached, 4 times indicted former president, who currently has 91 felony charges pending in both federal and state courts, wants them to. While Republicans say they need this inquiry to gather yet more evidence, they are deceiving themselves. They just don't like what the extensive evidence they've accumulated so far actually proves. President Biden and his administration voluntarily handed over tens of thousands of pages of private bank records, Treasury and National Archives documents. Biden administration officials from the FBI, the Internal Revenue Service, and the Department of Justice, along with Department of Justice special counsel attorney assigned to Hunter Biden case, have provided dozens of hours of sworn testimony. After extraordinary transparency from the Biden administration, the evidence proves that President Biden did not engage in any wrongdoing. The evidence proves that President Biden did not profit and did not engage in James or Hunter Biden's business. Further, President Biden respected the independence of the Department of Justice and retained David Weiss, the U.S. attorney appointed by President Trump as the special counsel leading the Hunter Biden investigation. The indictments this week of Hunter Biden prove that special counsel Weiss had full independent discretion to investigate and prosecute Hunter Biden free from political interference. But remember, impeachment is about what the president does, not what his son may have done. Biden's respect for the Justice Department is in sharp contrast to Trump, who urged his Department of Justice to investigate his political opponents. President Trump's own Attorney General, Bill Barr, had to resign in protest as Trump weaponized the Department of Justice after losing the 2020 election. Biden's respect for the law, no matter the consequence for his son, is the exact opposite of Trump's declaration he will be a dictator and will purge our agencies of our civil servants if he believes they are his enemies or unfaithful. Republicans often talk about Burisma, a far-fetched conspiracy theory, but Trump's own special representative for Ukraine negotiations, Kurt Volker, found that Burisma was based on a theory that, I quote, had been debunked, end quote. And there was, I quote again, no evidence to support it, close quote. The more than 39,000 pages of documents Republicans already received and the 62,000 on the way prove that President Biden follows the rule of law as he has done his entire career. He has fought corruption at home and abroad and has upheld his most sacred oath to the Constitution, an oath he has made 10 times throughout his dedicated career of public service. In contrast, we've seen House Republicans repeatedly conceal information, hide it from the public, and selectively leak lies and innuendo that distorts the truth. While the American public waits for Congress to do its job to fund our government and lower costs, extreme MAGA Republicans want an impeachment inquiry to create more division, more chaos. This do-nothing Congress is all about chaos. It's a do-nothing-but-chaos Congress. The American people know what evidence of high crimes and misdemeanors looks like. We know what it feels like. Evidence of an impeachable offense looks like the January 6th insurrection, where violent mobs stormed the Capitol and threatened to hang Vice President Pence and kill Speaker Pelosi. They attacked us because Trump wanted to delay the certification and overturn the 2020 election. That violent attack on our democracy led to the death of 5 law enforcement officers and seriously injured 140 more officers. When you walk out of this room, look with kindness and gratitude in your heart at the Capitol Police protecting us. They know what evidence of an impeachable offense looks like. They know what it feels like because they battled in hand-to-hand combat. That's what impeachable offense evidence looks like. Ask yourselves, what does my vote for the sham inquiry do to their sacrifice? You know, it's incredible. 197 Republicans voted against impeaching Trump for an insurrection that they witnessed and experienced firsthand as they ran for cover or barricaded themselves in their office. But now, they're going to be okay with continuing an impeachment investigation into Biden when a deluge of evidence shows there's no wrongdoing. Are you kidding me? On January 6th, Trump and the insurrectionists failed to overturn the election. The evidence of that day led to a bipartisan impeachment in the House, 57 senators voting to convict in the Senate, and a historic criminal felony indictment of President Trump. What the Republicans have done by bringing this inquiry is to highlight for every American to see two visions of what leadership for the greatest democracy in history looks like. The extreme MAGA Republicans' vision is that they must do all they can to bring back to power a president who brags about becoming a dictator, a president who conspired and then organized a violent mob to disrupt one of our most sacred democratic traditions, the peaceful transfer of power, a President Trump who desperately tries to punish his political enemies without any evidence of wrongdoing. Our democratic vision, and that of President Biden, is that no person is above the law. Our vision is of an American that respects the independence of the police, the courts, and our nation's justice system. Our vision is of a Congress that fights to make our communities better, rather than using our power and our precious time in this chamber for vengeance and to sow chaos. The differences could not be more clear. Democrats impeached a president. because he tried to overturn an election and destroy our democracy. Extreme MAGA Republicans are pursuing impeachment as political revenge because a man with 91 felony charges is telling them to do so. We heard the statements and quotes that our ranking member said, but there are so many more of President Trump's vengeance and his calls for revenge. I urge my colleagues to adopt this amendment so the record is clear that the evidence has been gathered, and that evidence proves that there is no need to continue this time-consuming political theater. I yield back.
Thank you. Is there any further discussion or debate on the amendment?
Mr. Chairman.
Gentleman from Texas is recognized.
I would note that we're here to talk about President Biden and an inquiry relative to President Biden. One of the whereas clauses here in the amendment that is offered says, whereas in the 11 months since the Republican-led committees, the Committee on Oversight and Accountability, the Committee on the Judiciary, the Committee on Ways and Means, first began their investigations, Republicans have received tens of thousands of pages, private bank records, Department of Treasury, National Archives, Federal FBI, IRS documents, and dozens of hours of witness testimony, including Special Counsel Weiss and other high-ranking officials at the FBI, IRS, and the Department of Justice, attorney assigned to Hunter Biden's case. Well, I think what's important here, and we're not here to litigate the merits of impeachment, but to simply proceed with a process for an impeachment inquiry for this body, the House of Representatives, to be able to conduct its oversight function when we have seen an extraordinary amount of stonewalling, contrary to what the ranking member said, out of this administration. Consider, for example, with respect to the IRS, Biden's Department of Justice has prevented two tax division officials, Mark Daley and Jack Morgan, from testifying, despite subpoenas. Now, this is particularly concerning given the indictment of Hunter Biden just this past week. According to these, to the IRS whistleblowers, both Morgan and Daley were involved in the decisions to not charge Hunter Biden with some of his most egregious tax crimes. IRS whistleblower Shapley said in 2021 that Daley had agreed with recommendations in the report to charge Hunter Biden for crimes in tax years 2014 to 2019. In June 2022, however, Morgan and Daley reportedly gave a presentation on why DOJ should not charge Hunter for the 2014 and 15 tax years. Well, that is particularly concerning, given the extent to which those have now been allowed to lapse with respect to the statutes of limitations. Morgan and Daley also have firsthand information about David Weiss's authority to charge Hunter Biden outside of Delaware, which could potentially contradict previous statements Weiss has made. On June 29th of 2023, the committees requested transcribed interviews with 11 DOJ officials, including Morgan and Daley. DOJ declined the request and multiple further requests. On September 14th, 2023, House Judiciary Committee issued deposition subpoenas for both Daley and Morgan. However, Department of Justice stonewalled the committee once again. Daley's personal counsel said the Department of Justice directed him not to appear. On November 1st, 2023, House Judiciary Committee issued a subpoena to Morgan that required his presence at a new deposition date. However, Morgan's personal counsel informed the committee that DOJ had directed him not to appear. Now, fast forward. December 7th, Hunter Biden's indicted. DOJ states, quote, a federal grand jury returned a 9-count indictment today, charging Hunter Biden with 3 felony tax offenses and 6 misdemeanor tax offenses. According to the indictment, Hunter engaged in a 4-year scheme in which he chose not to pay at least $1.4 million in self-assessed federal taxes he owed for tax years 2016 to 2019, and to evade the assessment of taxes for tax years 2018 when he filed false returns. Okay. My colleagues on the other side of the aisle want us to believe that that's some standalone problem for the president's son. But here's the problem. 4 months ago, the same David Weiss that we're talking about tried to bury the tax case against Hunter Biden. That's what happened. At that point, offering a no jail plea, important misdemeanors, basically a deal, pretty much out of the ordinary. And the problem with that is that now suddenly Weiss has moved a different direction because a judge called the deal out. He couldn't rationalize the plea bargain deal that he gave Hunter, and now he's making the case in the very indictment that he just put forward. The fact of the matter is there's been an extraordinary amount of stonewalling. This is one example of dozens that we could get into. And this is why the inquiry matters. This is why we should proceed with the inquiry. There are other issues that we could get into and raise, but to dismiss it and to just put aside and say there's been all of these investigations and there's been no issues that have been raised is just completely contrary to what anybody with eyes reading news accounts of what has occurred and looking at the indictment that was presented last week would understand. I yield back to the chairman.
Mr. Chairman?
Gentleman's recognized.
Appreciate the gentleman engaging, but let's be honest, we're here because Donald Trump asked you, no, demanded that you be here today to bring this inquiry forward. That is why we're here. Dozens and dozens of Republicans, and even Fox News hosts, let that sink in, have bluntly admitted that there's no evidence to support impeaching President Biden and have instead lamented that pursuing impeachment is not good for the country. Over the course of this year-long fishing expedition, because this is not beginning today, you've been doing this for over a year, House Republicans have poured over tens of thousands of pages of documents and financial records provided by the administration, have interviewed witnesses for dozens and dozens of hours, yet nothing they have revealed has supported their wild conspiracy theories and debunked the allegations. Nevertheless, here we are. But I think it's important to point out that this is a waste of time. I'm going to give you the words of Republicans. Don't take my word for it. Speaker Mike Johnson reportedly told his own colleagues, quote, that there is insufficient evidence to initiate formal impeachment proceedings. Rep. Mike McCall admitted, we don't have the evidence. That's his quote. Ken Buck, our colleague, the evidence for impeachment doesn't exist right now. He also said, I haven't seen any evidence linking Hunter Biden's activities to Joe Biden, and that I'm not convinced that the evidence exists. Rep. Dusty Johnson said, there's a constitutional and legal test that you have to meet with evidence when it comes to impeachment, but he has not seen that evidence. John Curtis, my bar for impeachment is incredibly high. For me, it's all about, is there an impeachable offense, and is there evidence of an impeachable offense? And when asked if he had seen anything that comes close to that bar, his answer was, quote, no. Darrell Issa, the former House Oversight Chair, said the actual participation by the Vice President and now President that still has to be discovered and or nailed down. Lisa McClain, when asked if the House Republicans, after nearly a year of investigation, had uncovered any improperly influenced policy decisions by President Biden, said, quote, the short answer is no. I could be here all day reading quotes from your colleagues, Republicans, who basically have publicly admitted this is a waste of time after a year, So let's be honest. We are here because Donald Trump ordered you to be here. He wants to finish the job. We're not here because there's any smoke. We're here basically because this is what the former disgraced president wants from you. And with that, I ask unanimous consent to insert into the record several pages of recent Republican quotes basically saying this is no evidence and a waste of time.
Without objection. Is there any further discussion of the amendment? The gentleman from Colorado is recognized.
I thank the chairman. The gentleman talked about stonewalling. I want to read him a quote. Quote, finally, allegations of obstruction ignore historic questions of privilege, ongoing litigation on the matter, and the fact that many executive branch witnesses testified. Democrats cannot complain about lack of participation when they created an environment that made testifying untenable. The American people will have the opportunity to decide in November 2020. We should let them, end quote. I suspect the gentleman recognizes that quote. Those are his words when he voted against impeachment of President Trump in 2019. So let's not pretend that this is not anything but the farce that it is. I understand the gentleman's position regarding President Biden, but the notion that this has any semblance of credibility or legitimacy is bellied by the facts. And while I would hope that my colleagues would apply some coherent consistency with respect to their views on impeachment, I'm not expecting that. But one thing that I certainly don't believe the American people can countenance is the notion that somehow this process is a fair one, or a transparent one, or an open one, or a necessary one. And that I would yield to my colleague from New Mexico.
Thank you very much. And I think that in response to this, the very fact that there is an indictment of Hunter Biden shows that President Biden and President Biden's Department of Justice stood back. And I think it's important to actually remember that Attorney General Garland recently reiterated his basic truth about this case. And he said, I promised the Senate when I came before it for confirmation that I would leave Mr. Rice in place and that I would not interfere with his investigation. And I have kept that promise. He also testified that there had been no contact with the president or the White House about the Hunter Biden matter. So all that you are doing over there of saying something has happened with Hunter Biden and we must raise it, and we must have more and more and more documents. Oh my God, almost 100,000 pages of documents already, and you can't find a link? Because we need to remember that this is about whether or not President Biden has done anything in the last 3 years. It's not about his son's action. Just as the impeachments of President Trump were about his conduct, and they weren't about how his kids or his son-in-law profited greatly from his presidency. They weren't about that $2 billion deal. They weren't about the money that those kids stole from a cancer charity. They were about what did President Trump do in office, not about his kid. And so this actually just proves the fact. So with that, I'll yield back to my colleague.
And I would echo my colleague's remarks and would yield to the gentleman from Pennsylvania.
The other thing that troubles me about this is that our colleague across the aisle has said that this has to happen because there's stonewalling. Stonewalling despite the tens of thousands of pages of evidence, the testimony by private individuals, et cetera. But he's ignoring the fact that this claim that these IRS folks have disclosed misconduct has been debunked by their own witnesses, by people from the U.S. Attorney's Office, by people from the Department of Justice, by people from the FBI, by agents from the IRS. They've said these people were wrong, yet our colleagues across the aisle cling to this misdirection and are using it to argue to their colleagues, oh, don't worry about it, this is just an inquiry. That's crap. I mean, this is, they have been given access to the evidence, they've been given unprecedented access to the evidence. Their own witnesses, their own documents have debunked the things that they are holding out there as evidence of some fictitious misconduct. So I yield back.
And I yield back.
Is there any further comment or discussion of the amendment? Gentleman from Pennsylvania is recognized.
Thanks, Mr. Chairman. I appreciate it. You know, I think we just have to level set here. We got to remember that we're here dealing with an inquiry. This has nothing to do with the former president. This has nothing to do with articles of impeachment. This resolution establishes nothing more than a process to follow the evidence and assert our Article I authorities. By the way, Article I authorities that Nancy Pelosi greatly reduced. But again, any talk that is outside of the process, outside of producing witnesses, outside of compelling compliance with subpoenas, for example, is irrelevant to the discussion. We're here simply talking about moving forward with the process. With that, I yield back.
Is there any further discussion on the amendment? Hearing none, the questions on the amendment, all those in favor signify by saying aye. Aye. Those opposed say no. No. The opinion of the chair, the noes have it. Recorded vote's been requested. The clerk will call the roll.
Mr. Burgess.
Burgess votes no.
Mr. Burgess, no. Mr. Reschenthaler. Mr. Reschenthaler, no. Mrs. Fishbach. Mrs. Fishbach, no. Mr. Massey. Mr. Massey, no. Mr. Norman. Mr. Norman, no. Mr. Roy. Mr. Roy, no. Mrs. Houchin. Mrs. Houchin, no. Mr. Langworthy. Mr. Langworthy, no. Mr. McGovern. Mr. McGovern, aye. Ms. Scanlon. Ms. Scanlon, aye. Mr. Neguse. Mr. Neguse, aye. Ms. Leisure Fernandez. Ms. Leisure Fernandez, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 9 nays.
Noes have it. The amendment's not agreed to it. Are there additional amendments?
Chairman, I have an amendment at the desk.
Clerk will report.
Amendment number 3 to House Resolution 918, offered by Ms. Scanlon. Before the resolve clause, insert the following. Whereas, in their investigation, the Republican majority has received 38,000 pages of financial records, including bank records for the personal accounts of members of the president's family and other private citizens, over 2,000 pages of Treasury Department reports, and tens of thousands of pages of records and emails from the National Archives from President Biden's service as vice president. Whereas Hunter Biden has offered to testify publicly under oath as part of the investigation. Whereas House committees have heard dozens of hours of testimony from Hunter Biden's business partners and then Vice President Biden's financial advisor, 3 current U.S. attorneys and Department of Justice officials, and 4 current Federal Bureau of Investigation and Internal Revenue Service supervisory special agents, and unprecedented testimony from Special Counsel David Weiss on an ongoing investigation. Whereas the FBI and Treasury Department have provided access to and briefings on highly sensitive law enforcement documents. Whereas the National Archives have produced 62,000 additional pages of then Vice President Biden's records this week, and in addition to the 20,000 pages already publicly available. And whereas, at the end of June, Committee on Oversight and Accountability Chairman James Comer said in an interview, "Every subpoena that I have signed as chairman of the House Oversight Committee over the last 5 months, we have gotten 100% of what we requested, whether it's with the FBI or with the banks or with Treasury. Now, therefore be it."
Gentlelady is recognized on her amendment.
Thank you, Mr. Chairman. Since the stated purpose of launching this inquiry is the false claim that President Biden has stonewalled this sham investigation, the purpose of this amendment is to detail the unprecedented and extensive cooperation provided by the President, his family, and this administration, despite the absence of any constitutional basis for this sham political stunt. I want to remind everyone again what's really going on here. It's as simple as this. House Republicans have wasted the past year on a cheap political stunt. The people who send us to Washington do so with the belief that we will work to make their and their families' lives better. But as we've seen all year, the extremists who have put the House majority into a chokehold aren't interested in keeping up their end of the bargain. And now they've brought us here today to waste more of the American public's time and tax dollars on petty political vengeance. In case it isn't clear already, constitutional scholars are not driving this impeachment inquiry. Instead, the former president's lackeys here in Congress are running the show, holding the floor hostage as they attempt to curry favor to obtain pardons or positions in a second Trump administration. Meanwhile, the rest of their conference seems content to sleepwalk into dictatorship as they yield what remains of their consciences to the most extreme members of the Republican Party. My amendment would shine some light on this shameful process and expose it for what it really is, a circus and a farce cooked up to placate the disgraced, defeated, and twice impeached former president. You know, there's a term for what House Republicans have proposed with their resolution today to start an impeachment inquiry. It's called a kangaroo court, a court in which the principles of law and justice are disregarded or perverted to reach a predetermined conclusion. This is my favorite definition, a mob-operated tribunal that disregards or parodies existing principles of law. That's what we're dealing with here, a MAGA kangaroo court, engaged in a desperate search for evidence to prop up a predetermined conclusion, and in which they're willing to subvert both the truth and the Constitution in a naked political stunt. For the past year, President Biden and his administration and his family members, private citizens with no role in the government, unlike the former guy, they have shared tens of thousands of documents with this kangaroo inquisition, including emails, financial records, and Treasury Department reports. They've responded to extreme Republican requests, no matter how absurd. Chairman Comer of the Oversight Committee has admitted this himself, saying, every subpoena that I have signed over the last 5 months, we've gotten 100% of what we requested. Numerous individuals, including private citizens, U.S. attorneys, Department of Justice officials, a special counsel overseeing an ongoing investigation, and federal law enforcement agents have made themselves available for dozens of hours of testimony and interviews. Federal law enforcement officials have provided briefings and access to highly sensitive documents. The president's son has offered to testify publicly under oath in front of Congress and the country, an offer that the Republicans have rejected. Extreme Republicans will continue trying to muddy the waters, attempting to drag the president and the American people down a rabbit hole of conspiracy theories and untruths to support their MAGA kangaroo court. But the public knows this is a sham. The fact is that Chairman Comer and the rest of the so-called investigators have seen everything. Their fundamental problem isn't a lack of evidence. They have mountains of evidence. Their problem is that none of it proves their baseless accusations, and they know it. They can't even look at us. Dozens and dozens of Republican members and even Fox News hosts have admitted on the record there's no evidence, and they know it. But instead of admitting that, Republican leadership has yielded to the blackmail of the MAGA mob and agreed to spend our last legislative days of the year wasting more time to prop up a floundering, dead-end investigation. And in doing so, they further their attempts to chip away at the legitimacy and core values of our country's institutions. The American people deserve better than this. I encourage all of my colleagues to support my amendment to shine transparency and truth onto this extreme, illegitimate stunt. I yield back.
Gentlelady yields back. Is there further discussion or debate on the amendment? Gentleman from
I'll
Pennsylvania.
yield to the ranking member. I'm sorry, Mr. Chairman. Okay. Thanks, Mr. Chairman. I appreciate it. So again, I got a level set here. We got to remember that these documents that my colleagues are talking about that were produced, these weren't just freely given documents by the good graces of the Biden administration, or the Biden family, rather. Those were given to the House by whistleblowers. Whistleblowers, I might add, that had been vilified by the far-left Democratic extremists. And the bank records, these bank records weren't freely given by the Biden administration. They weren't even freely given by the banks. The banks received subpoenas, and that compelled the production of the bank records. So if again, we're talking about a process here. There should be, if there's nothing to hide, why not just go through the process? Why not just have this so we can compel the production of documents, so we can compel the testimony of witnesses and force some depositions? If there's nothing to hide, there should be no issue with following the process. So again, I want to level set and just set the stage for why we need these documents. And again, what we have received has not been freely given. With that, I yield back.
The gentleman yields back. Is there further discussion or debate? Ranking member,
First, I want to ask
recognized.
unanimous consent to insert in the record two different letters, one from the Trump White House and one from the Biden White House. You know, we hear a lot about stonewalling. I mean, the cooperation has really been unprecedented, but let me just read one excerpt from this was in response to the inquiry regarding President Trump. The White House's response to Congress was, given that your inquiry lacks any legitimate constitutional foundation, any pretense of fairness, or even the most elementary due process protections, the executive branch cannot be expected to participate in it. Consistent with the duties of the President of the United States, and in particular, his obligation to preserve the rights of future occupants of his office, President Trump cannot permit his administration to participate in this partisan inquiry under any circumstances. Now, we're going to contrast that with the response that Mr. Comer and Mr. Jordan received from this White House, again, basically saying we believe in engaging in good faith is critical to avoid constitutional conflict, and we propose a meeting with your staff to start this important process. Given the compressed timeline created by your waiting nearly 3 weeks to respond to our prior letter, we expect that you will put down the return date for your subpoena to allow accommodations process to proceed. Basically, it's a tale of two approaches. One administration that wants to stonewall, that was Trump, and then this administration that has cooperated.
Without objection.
But I just want to close with this. This is breaking news for everybody. So our Republican colleague, Don Bacon, just a few minutes ago told a small group of reporters this morning that there are, quote, probably not high crimes or misdemeanors that Joe Biden has committed. Yet he still plans to vote to authorize this impeachment inquiry, notwithstanding that there's no there there. I guess the question is, when are people going to stand up and end this extreme political stunt? This is not the beginning of something. This should be the end of something. You've been doing this for over a year, and there's nothing there. There's no smoke. And so this is a colossal waste of time. I yield back, Mr. Chairman.
Gentleman yields back. Is there further discussion or debate on the amendment?
Mr. Chair.
The gentlelady from New Mexico is recognized.
Just in response to the idea that this is about creating a process, I just want to reiterate what both the ranking member has said, what Representative Scanlon has laid out in detail. A process has been ongoing. Subpoenas were issued. Subpoenas were responded to. Documents were provided. They were provided in many different ways. And that is indeed a process. There is no evidence of anything but that, as pointed out earlier, President Biden's a good father. President Biden fought corruption. President Biden was not involved in Joe or Hunter Biden's business dealings. That's what the documents have proven. What this process is keeping this story alive, is keeping Congress involved and distracted by this impeachment idea, conspiracy thought, thought process, because it's like coming from above because there is no documents. We already have a process that we followed. And the idea that this is just about a process, we need to look at Newsmax. Chairman Comer actually said, I'd indict tomorrow before they even began this process. They were talking about impeaching. They were not waiting for a process. And Mr. Chair, I would yield to my colleague.
Gentleman's recognized.
Thank you, Mr. Chairman and Ms. Ledger-Fernandez. And I couldn't agree more. Again, perhaps the most frustrating element of this exercise is the intellectual dishonesty to pretend that this is anything but a fait accompli. There isn't a single one of you who's going to vote against impeachment if articles are brought to the floor 4 weeks from now, 8 weeks from now, 12 weeks from now. So pretending as though this is just somehow a very simple step forward to approve a perfunctory or cursory process is not level setting with the American people. It is one of the most solemn votes that any of you will take in your careers. I suspect none of you have voted in the past to initiate an impeachment inquiry. So treating it in this cursory way, as the gentleman from Pennsylvania apparently wants the American people to believe, as I said, is inconsistent with the constitutional nature of impeachment, the weightiness of impeachment and proceeding on this course. And I would hope it would give some of you some pause. It's clear that that hasn't been the case. I yield back to the gentleman.
And thank you. With that, Mr. Chair, I yield back.
Gentlelady yields back. Is there any further discussion or debate on the amendment?
Mr. Chairman.
Gentlelady from Minnesota is recognized.
Mr. Chair, I would yield to my colleague from Pennsylvania.
Gentleman's recognized.
I'd like to thank my good friend. Again, just a level set, we're here talking about a process. And it's one thing to cherry pick lines from either this White House or the last administration. At the end of the day, we're here protecting our Article I authority. And we're here largely because the Biden administration lawyers are saying they don't have to face the subpoenas, they don't have to compel this evidence because we haven't had this vote. So they're the ones that are saying we don't have to be here. We are trying to set this up so that we can get all the evidence and have this. But again, this is about the process, and this is about, absolutely.
The gentleman served with me on the Judiciary Committee 4 years ago in 2019. Right?
I'm sorry.
President Trump demanded that Don McGahn not testify in the Judiciary Committee, that not a single document be produced by the White House, that not a single executive branch employee be allowed to testify in front of the United States Congress. I didn't hear much about Article I authorities from you or any of my colleagues in the Judiciary Committee. You were there with me.
Yeah, I yielded time that wasn't mine.
Sure.
So I apologize to my colleague. Here's the thing, that once the rules have been changed, the rules are changed. So now you can't say that what was good enough for President Trump is no longer good enough for President Biden. So the Democrats shifted the standard. Frankly, now impeachment, you could view it as almost a political exercise. We're moving forward. Anytime you have a president of a different party than the House, there's going to be calls from whatever base it is, whether it's Democratic base or Republican base, because of that. But that's not the Republican standard. That was the standard that was set by the Democrats in the last administration twice. But again, this is about our Article I authority. This is about making sure that we have this vote because the Biden administration is saying they don't have to produce the documents or compel witnesses to testify in depositions because we haven't had this vote. And with that, the gentlelady has been very generous with her time. I yield back.
Gentlelady yields back. The gentleman from Texas is recognized.
Yeah, I would just note that again on the merits, right? There's going to be a lot of back and forth about who did when in different circumstances. But on the merits, the question here isn't about production of documents. Anybody who's ever been involved with subpoenas and presentation of documents knows that document dumps are fairly normal. The question is what is actually being presented? What is being shared? The Oversight Committee has identified 82,000 pseudonym communications that could, and this is the whole point of an investigation, contain key evidence for which they've only received 14 documents. These are the questions about the pseudonym emails that have been identified, 29,000 of which are between the Office of the Vice President and the family's businesses. So for those of us who are concerned about the flow of international dollars into the Biden family, which is hard to even dispute based on the indictment that is now sitting before us with respect to Hunter and where he's gone with his tax records, but importantly, what we know from other evidence about the extent of the millions of dollars flowing into the Biden family, Hunter, and other members of the family. The question is, well, what did the vice president know when he was vice president? What did the president know? What did he know between those times? That's the point of the investigation. Again, we have 82,000 pseudonym communications, 29,000 between the Office of the Vice President and these family businesses, and yet we only have 14 of those produced. We still have the subpoenas outstanding for Mark Daley and Jack Morgan that I alluded to before that are not being responded to. The reason is because those go to the heart of the problem. Those get to the heart of the question. So the point here, and with respect to previous quotes and so forth, the quote that the gentleman was referring to was my conclusion at the end after the inquiry is my conclusion about that point is said with respect to the articles. My point here is with respect to an inquiry, and look, again, none of us are perfect to go through this. I just went back and reread the op-ed I wrote on December 11th, 2019, in which I concluded not to support the impeachment articles. But notably, I presented that I did not think the phone call was perfect. I did think there were issues that merited looking into when I was sitting before all of that to make sure we understood exactly what the communications were. The point is we should pursue all of the facts wherever they may lead as the body in Article I that is supposed to be checking Article II. And in this instance, what we're looking at here are very important unresponded to queries by this branch, Oversight and Judiciary and others, to the administration. Again, what are we concerned about? What are we afraid about learning from Daley or Morgan? Why do we not want to make sure that Daley and Morgan come forth and testify? Why would that be concerning? Why do we not want to have those emails that are potentially pseudonym emails, as we understand it, in terms of the communications between the office of the vice president and the family businesses, when we're talking about millions of dollars flowing from international sources with all sorts of connections with people who have testified on the record, Devin Archer and others, about where the president was and the president's knowledge of the existence of these family businesses and the fact that they were selling, quote, the brand. There is significant amount of evidence that has come forward that raises questions that this body should want to know the truth about. I yield back.
Mr. Chairman?
Gentleman's recognized.
Yeah, I think I need a decoder ring to follow what the gentleman was just saying. I mean, look, an unprecedented amount of cooperation from this administration. National Archives has listed the number of documents that have been turned over that have been asked for. Chairman Comer said, every subpoena that I have signed as chairman of the House Oversight Committee over the last 5 months, we've gotten 100% of what we requested, whether it's with the FBI or with the banks or with the Treasury. That's Chairman Comer, the guy who said that he would vote to indict Joe Biden on day one before he's seen any evidence. And I want to thank the gentleman from Pennsylvania, who's no longer with us, for his honesty when he basically said that this is a political exercise. So he is absolutely correct. This is a political exercise, pure and simple. You can try to dress it up all you want, but that's what this is. And I appreciate and I want to thank him for his honesty. And with that, I yield back.
Mr. Chairman,
The gentleman from Kentucky is recognized.
just in defense of the gentleman who's not here, what he said, I believe, is that the standard was lowered by the other side of the aisle to a political exercise. And I just wanted, for the record, since he's not here to defend what he said, wanted to set that straight.
Appreciate that. The gentleman from South Carolina is recognized.
Chen, I think it's really humorous, the fever that I see from the other side to continually bring up Donald Trump. This is about Joe Biden. And to put some context to the money we're talking about, from 2014 to 2019, Biden family members and their affiliate companies received over $15 million from foreign companies and foreign nationals to Ukraine, Russia, Kazakhstan, Romania, and China. Biden business associates received an additional $9 million. For the president's contention that he didn't know anything about it, wasn't anywhere near his son's business dealings. Devin Archer, who was a longtime Biden associate, described the Biden brand, as Chip noted, and how Hunter Biden placed Joe Biden on phone calls, including on speakerphone 20 times with business associates. And, you know, for y'all to just want to water this down and say it's nothing, what are you scared of? What are you scared of the facts? This is an inquiry that's going to go. It should have started, you're right, it should have gone far longer than this. How many happened under Nancy Pelosi? 0. We took over in January. I think Kevin put the date is September 13th and 14th to do the special inquiry. These are facts. These aren't small things. There's got to be consequences for this guy.
Would the gentleman yield?
Oh, yes, ma'am.
Oh, thank you so very much. You know, and I think that pointing out those comments from Mr. Archer is really important, because we actually have the transcript, and I'll address that later. But if you actually look at that transcript, Mr. Archer is very clear that while the father may have talked to his son, they never ever talked about business. They never ever talked about financial matters. And in contrast, when we are looking at issues about family business, I would like to enter into the record, Mr. Chairman, I seek consent to enter into the record, a Politico fact that says Trump taxes show foreign income for more than a dozen countries. And I think this...
Without objection.
I think that it is important. You are making a big deal of the fact that Joe Biden, as a private citizen, a lot of these things that you're talking about happened when Joe Biden was a private citizen, but more importantly, that his brother and his son were separate. They did not have, their businesses were not commingled. It's very clear from the evidence that they were separate. They were not the same. In contrast, we know from this article that says Trump tax assure foreign income, Donald Trump's tax returns show the former president received income from more than a dozen countries during his time in office, highlighting a string of potential conflicts of interest. It took a lengthy legal fight to be able to get those documents, and it included money from the United Arab Emirates, from China. There was a lot of money made by Trump because President Trump kept ownership of those businesses. So I think it's really important to make the distinction that, yes, Joe Biden has a brother and has a son, and they have businesses, but that is not Joe Biden's business. And that is the key. Here we are looking at what did the president do as president, in contrast to what President Trump did, which was get a whole lot of money, tell a whole bunch of people, you better book your hotel stays at my properties while he was president. That is the contrast of what we're dealing with. And with that, thank you so much for yielding the time.
Sure.
I appreciate it.
Mr. Lega Fernandez, here's the difference. You've got a businessman that made his money long before he got into politics. What these facts or what we will find out is, and try to figure out, what service did the Bidens provide? What expert was Hunter to get the $24 million and the rest of the family members? That's what we're trying to get to the bottom of. He's no businessman. He's a politician. And let's let the money trail follow and try to figure out, like his paintings, where did they come from? Where did the money come from? Let's follow the trail. This is a joke, if it wasn't so serious, with the money that this man apparently had. And he's, from day one, didn't know anything about it, never had any involvement. He's on phone calls. How about the pseudonyms? What is that? I think in time, what y'all are trying to do is stall and prevent any information, more information from coming out. And the American people deserve better. And if he's innocent, as he says he is, let the facts show it. I yield back.
Mr. Chairman, just briefly.
Gentleman is recognized.
Oh, I just want to say to the gentleman, I think he just read from the Republican leadership talking points that went out. I will assure him that almost everything he has said has been disproven or discredited already. We're happy to share that with him. But when he said that this is not about Donald Trump, I strongly disagree. Again, this is Donald Trump's quote, either impeach the bum or fade into oblivion. And unfortunately, my Republican colleagues are so fearful of him, are so afraid of him, that they do whatever he asks them to do. That is why we are here. We are here because of Donald Trump. We are here because the insurrection did not succeed on January 6th, and this is about finishing the job. So let's not kid ourselves that Donald Trump doesn't play a role here. I yield to the gentleman.
I would completely agree with the ranking member. USA Today, which is from last week, from December 4th, USA Today. Quote, if Trump, who has been impeached twice, is the 2024 Republican nominee, Rep. Troy Nails said he wants to give Trump, quote, a little bit of ammo to fire back, end quote, and say Biden has also been impeached, end quote. So the suggestion by the gentleman from South Carolina, by the gentleman from Pennsylvania, that this has nothing to do with Donald Trump is divorced from reality. You know it, we know it, the American people know it. This is being done at the behest of former President Trump. Why? Because he remains singularly focused on exacting retribution for being impeached in a bipartisan manner for his actions on January 6th. That's it. The rest of this is theater. I yield back to the gentleman.
I think I yield back.
Is there further discussion or debate on the amendment? Hearing none, the questions on the amendment. All those in favor signify by saying aye. Aye. Those opposed say no. No. The opinion of the chair, the noes have it. The gentlelady has requested a vote. Clerk will call the roll.
Mr. Burgess.
We're supposed to know.
Mr. Burgess, no. Mr. Reschenthaler. Mr. Reschenthaler, no. Mrs. Fishbach. Mrs. Fishbach, no. Mr. Massey. Mr. Massey, no. Mr. Norman. Mr. Norman, no. Mr. Roy. Mr. Roy, no. Mrs. Houchin. Mrs. Houchin, no. Mr. Langworthy. Mr. Langworthy, no. Mr. McGovern. Mr. McGovern, aye. Ms. Scanlon. Ms. Scanlon, aye. Mr. Neguse? Mr. Neguse, aye. Ms. Ledger-Fernandez? Aye. Ms. Ledger-Fernandez, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 9 nays.
Noes have it, the amendment's not agreed to. Are there any further amendments?
Mr. Chairman, I have an amendment.
Gentleman from Colorado is recognized. Clerk will report the resolution.
Amendment number 4 to House Resolution 918, offered by Mr. Neguse. Page 2, line 7, strike investigative and insert the following: open and transparent investigative. Page 6, line 1, strike investigative and insert the following: open and transparent investigative. Page 9, line 19, strike investigative and insert the following: open and transparent investigative.
The gentleman's recognized on his amendment.
I thank the chairman. I hesitate to belabor the arguments I've made already regarding what I consider to be and what I think the American people would find to be a baseless impeachment process that Republicans have initiated. It's a political stunt. The American people know that to be the case. They know that because there's been no cogent articulation by my colleagues on the other side of the aisle as to what crime they're actually investigating, no connection to the constitutional standard for impeachment. But one of the other reasons they know this to be true is because of the sham process that Republicans have initiated. And this amendment seeks to at least rectify that glaring defect. And while this amendment, of course, has an audience of the entire committee, it perhaps has an even more targeted audience of one or two of my friends on the other side of the aisle who have spoken in the past about transparency, and I'm hoping maybe Mr. Massey or Mr. Roy might engage me in a colloquy about the merits of this particular amendment. It's very simple. Thus far, Republicans have engaged in a process that's been largely behind closed doors. Ms. Ledger-Fernandez recounted this in great detail. The fact that so many of the interview transcripts have been hidden from the public, the fact that witnesses who have sought to testify in public, including the president's son, have been impeded by the committee from doing so. We went back and looked. The resolution that initiated the impeachment inquiry into former President Donald Trump is very similar in terms of the language, that essentially Republicans have attempted to try to emulate different provisions of it. But there was one glaring omission, which is that in that resolution in 2019, prefaced behind every component paragraph that describes the investigation that the committees of jurisdiction would be engaged in, was a commitment to, quote, open and transparent investigative proceedings. 3 words: open and transparent. Those 3 words were deleted by Republicans in this resolution. And so this amendment is very simple. It's very straightforward. It's not a gotcha amendment. There's no hidden door. It's simply asking my colleagues to add that phrase, open and transparent, to the resolution as a prefatory clause before the description of each investigative committee of jurisdiction. Because thus far, the process has been anything but. And so it makes sense to me why Republicans didn't include the phrase open and transparent, because the process has not been open and transparent. So I don't think this was an accident. It wasn't an error by omission. It was intentional. There's a great way for the Republicans, my colleagues, my friends on the other side of the aisle, to perhaps prove the contrary, which is to support this amendment. With that, Mr. Chairman, I'm happy to yield to the gentleman from Kentucky.
Words are words, but the problem is I served on the Oversight Committee when the Democrats did their inquiry, and that happened 3 floors underground in a skiff where nobody could bring their cell phones. I sat down there for hours, and what happened is there was no semblance of openness, or you would be arrested and taken to jail if you tried to witness what was happening inside of that skiff. For weeks, I sat down there with Ambassador Sondland. I sat down there with Lieutenant Colonel Vindman. There was no openness, no transparency, unless you count Adam Schiff running out every time he got a nugget of something that he could leak. And that is exactly how I witnessed that process. Was the gentleman on the Oversight Committee or the Intel Committee at the time?
No, I was on Judiciary.
So if
But I guess
you've
the
been
question
on
to
either
you-
of those committees,
You know, and I understand the argument you're making. I would say a couple things. First, the resolution, again, you all used it as you essentially took different provisions and modified them and so forth. The inquiry resolution was following those interviews, as I can best recollect, from back in October and September of 2019. The inquiry resolution that you all have essentially used as a template was after that. And essentially what the resolution then compelled, for example, HPSI to do was to shall hold public hearings and shall issue a report on its findings. Your resolution, and of course included that's why the open and transparent language was included. This resolution does the opposite. That's all I'm trying to figure out is why not say the Oversight Committee is going to have, quote, open and transparent proceedings. We're going to require them to hold a public hearing, and we're going to require them to issue a report. Why is the language permissive, and why has open and transparent been deleted? And this isn't a political argument. It's a good faith question.
which I answered with a question, why were we in a skiff for weeks?
What I'm saying to you is these
when
resolutions.
the Democrats were investigating?
I hear you. What I'm saying to you is this inquiry resolution and the inquiry resolution that was adopted at the end of October in 2019 are both taking place after 10 months, 11 months of process. You've described what you contend are closed-door hearings that HPSI conducted, interviews, that they conducted. Obviously, you've heard us talk about closed-door interviews that Oversight has conducted. My point is that at the impeachment inquiry phase, when we took that vote, from then on, everything was public, which is why the resolution was structured as such. In this instance, Republicans have removed it, and it's clear that they don't intend to have a public process. That's what I'm asking.
Well, I suspect at some point the other side of the aisle will claim that the information that's being publicly released has no business being in the public about bank records and things like that. So maybe it's an effort to respect the wishes of the other side.
Oh, I'm sure that's the reason, Mr. Massey.
But I yield back.
I thank the gentleman. I'm going to yield to the ranking member. I'll just simply say again, this is a good faith argument. It's not complicated. Adding open and transparent to make a commitment to the American people that you're actually going to conduct a process that is open and transparent shouldn't be complicated. It shouldn't be difficult. And I don't know why. I get it. I understand your opposition to some of the other amendments, including amendments that I'm going to offer, but this really shouldn't be one of them. And I'll yield to the ranking member.
No, I think I may have an answer for you. I'm reading USA Today. There's an article, host Republicans, talking about how they omitted open and transparent from the resolution, and the excuse, the rationale that a Republican aide gave was that keeping open and transparent in was wordy. Really? I mean, open and transparent, 3 words, too wordy? That's the excuse to eliminate it? It's laughable. This is ridiculous. Again, I think we all should agree that this should be open and transparent. It was in the previous resolution when we were in charge. Let's just put it in. That's a sign of good faith. But to say this being omitted because it's wordy, come on, give me a break. I yield back.
I yield back. All right, yield to
I don't know whose time it is, but I assume it's the chairman's time, so I appreciate it. Look, again, I've got to just level set here. This amendment literally does nothing other than change the wording of the subheaders. And the ranking member just admitted that. We're here talking about changing investigative to open and transparent. Investigative. That's it. Just to put this in perspective, I have the side-by-side comparative, the 116th and the 118th resolution.
Well,
And
why delete it?
Why'd you delete it?
Because we have, our hearings have been in the open. They've been open and transparent to begin with.
Deliberately deleted this, why?
And again, I was, with what Mr. Massey was talking about, I was on judiciary. A lot of those meetings were, in fact, most of them were in a skiff. And as Mr. Massey said, had we come out of that skiff and reported what was being said and conducted, we would have been arrested and gone to jail. Our process here has been absolutely open. The public has been included, told, as compared to what Speaker Pelosi did, where again, we were 3 levels below ground in a skiff. So I just don't think this is necessary, but.
Just for the record, the gentleman does control the time, so.
Okay, thanks.
Gentleman yield?
I'll yield.
Yeah, I mean, again, these words were deliberately deleted. And my friends keep on saying to us, it's not about Trump, it's not about Trump, it's not about Trump, but now it's about Trump. So you can't have it both ways. But again, deliberately deleted the words open and transparent. And with all due respect, the process that you are conducting right now, I don't believe is open and transparent. And by the way, I mean, I'm not on the Oversight Committee either, but some things, you know, especially on the first impeachment, were classified, and there was a reason for some of that. But again, all we're asking for is the gentleman to put back in the words open and transparent. For some reason, Republicans deliberately removed it. None of us can figure out why, but I support the gentleman's amendment. I yield. Thank you for yielding.
I yield back. Thank you, Mr. Chairman.
Thank you very much. Is there any further discussion or debate on the amendment? Hearing none. Questions on the amendment? All those in favor say aye.
Aye.
Those opposed say no. No. Noes have it.
As for your recorded vote.
Recorded vote's been requested. The clerk will call the roll.
Mr. Burgess. Mr. Burgess, no. Mr. Reschenthaler. Mr. Reschenthaler, no. Mrs. Fishbach. Mrs. Fishbach, no. Mr. Massey. Mr. Massey, no. Mr. Norman. Mr. Norman, no. Mr. Roy. Mr. Roy, no. Mrs. Houchin. Mrs. Houchin, no. Mr. Langworthy. Mr. Langworthy, no. Mr. McGovern. Mr. McGovern, aye. Ms. Scanlon. Ms. Scanlon, aye. Mr. Neguse. Mr. Neguse, aye. Ms. Leisure Fernandez. Ms. Leisure Fernandez, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 9 nays.
The noes have it. The amendment's not agreed to. There are additional amendments.
Mr. Chair.
The gentlelady from New Mexico is recognized.
Mr. Chair, I have an amendment at the desk.
Clerk will report the amendment.
Amendment number 5 to House Resolution 918, offered by Ms. Leisure Fernandez. Page 2, line 14, strike may and insert the following: shall. Page 6, line 8, strike may and insert the following: shall. Page 10, line 2, strike may and insert the following: shall.
Gentlelady is recognized on her amendment.
Thank you, Mr. Chairman. I think this is a follow-up to the earlier amendment about the need for open and transparency in this process. But going to Mr. Reschenthaler's thought is, how do we do that? And I think one of the ways we do that is require, not permit, but require that the committees hold open hearings. It's simple. We always hold open hearings. This hearing that we are engaged in right now is open, and the American public is able to see what our arguments are, is able to determine, well, does this make sense? What should we be doing? What is the evidence? We need that, because right now, in the evidence that we, as Congresspeople, have been able to see, we know that there's clear and compelling evidence in the 100,000 pages of documents and the hours of testimony that President Biden was not involved in and did not profit from his brother or his son's business dealings. So in response to Mr. Norman's concerns about where does that evidence lead, the evidence in the record actually already shows that there was no connection. It's available, though, in closed door hearings and transcripts and meetings that are not easily accessible to the public. Extreme MAGA Republicans seem to want to do their work behind closed doors and in secret. My amendment would simply require that we hold open hearings. We need open hearings because for 11 months, we've seen Republicans on these investigating committees distort the evidence they've received behind closed doors. Debunked. fact-checked, not true, distorted, mischaracterized, and misused. These are the terms that we keep seeing regarding the Republican statements about the record so far. Representatives Bober and Marjorie Taylor Greene are prime examples of misrepresenting the facts they hear behind closed doors. On July 31st, Representative Bober tweeted, I quote, "Devin Archer confirmed that the big guy participated in more than 20 of Hunter's shady business deals," close quote. That same day, Representative Marjorie Taylor Greene told a reporter that Devin Archer said he heard Hunter Biden speak to his father 20 times about only their business dealings. The transcript of what Archer actually said is that Archer told the committee that he did not, open quote, witness specific business deals or business dealings or specifics about any kind of financial stuff, unquote, between Hunter and his father. What did Archer say Joe Biden actually talked to his son about on these calls? Mr. Norrin might be very interested in this, because what Archer actually says they talked about in those 20 calls is the weather, geography, how's the fishing? They were, in Archer's terms, casual conversation. The news articles reporting these discrepancies say the transcription shows the opposite of what Marjorie Taylor Greene and Lauren Boebert claim. Something that is the opposite of the truth could be described as distortion or simply a lie. Una mentira, as we would say in Spanish, a lie. Mr. Chairman, I request unanimous consent to enter into the record the transcript of the Archer's testimony.
Without objection.
And because it is a big document, the article titled Transcript of Devin Archer Testimony doesn't back key claims about Joe and Hunter Biden.
Without objection.
Chairman Comer, who has appeared before us and who I respect, has been leading the investigations into President Biden. Unfortunately, Chairman Comer has also misrepresented facts. Indeed, the Washington Post reported that Republican leaders exaggerate their partisan reports in the media to claim wrongdoing by President Biden. The Washington Post noted that Comer and other GOP lawmaker claims eventually lead to reporting that is, quote, untethered from the documentation in the reports, unquote. Untethered. That means it's untethered from truth. It's untethered from what's actually in the reports. The Washington Post further noted that, open quote, Comer would have more credibility if he stuck to documented facts, close quote. Mr. Chairman, I request unanimous consent to enter into the record the article titled, How Republicans Overhype the Findings of Their Hunter Biden Probe.
Without objection.
Republicans are hiding the facts and then lying to the public about them. There have been 11 months of investigation, almost all of which has happened behind closed doors. And now they want to continue that investigation, continue those committee hearings in secret. What are they afraid of what the public's going to see? Maybe that there's no evidence of wrongdoing by President Biden and that this inquiry distracts from the important work Congress should be doing, because Republicans continuously distort the facts to fit their preferred narrative. They've lost all credibility, as this newspaper article notes. Just a couple of weeks ago, Oversight Committee Republicans claimed that Hunter Biden received payments from Chinese companies and nefariously gave some to President Biden. But then we found out that hadn't happened at all. We found out that Joe Biden had helped his son make his truck payments while Hunter was struggling with addiction and in and out of rehabilitation. In 2018, before Joe Biden even ran for president, Hunter repaid his father the sum of $4,140 for a truck payment. Now, Republicans are trying to turn this $4,140 worth of help during Hunter's time of struggling with addiction into an impeachable offense. A parent's love is never without pain. The pain of watching your child struggle with addiction, as something that too many Americans know intimately, something my own mother knew as she lost 2 sons to this accursed affliction, but not before she tried to help them. What parent in America would stop loving their child because that child spiraled into addiction and needed help? Americans will see in Joe Biden's truck payments some of their own actions to help their struggling children. Shame on my Republican colleagues for trying to turn this fatherly love into an impeachable offense. Shame on their attempt to politicize a parent's pain and goodness. I urge my colleagues to adopt this amendment to require public hearings, and I yield back.
Is there further discussion on the amendment? The gentleman from Pennsylvania is recognized.
Okay, once again, just a level set, here's some facts on transparency. So the Oversight Committee has already had 4 memos detailing the bank records. Of course, those have been open to the public. They've had 2 public hearings. They've also released full transcripts of those hearings to the public. They've continued to update, not just Chairman Comer, but Chairman Jordan, Chairman Smith have been on TV, they've been on print. You can't turn on a news program without seeing one of those 3 update the American people on this. So to say that we somehow lack transparency is laughable, especially when you compare it to the 116th, when even after the committee went forward with the impeachment inquiry vote, the Intel Committee continued to hold hearings in a skiff. Again, so the transparency argument is laughable in the face of the 116th and in the actions of just the Oversight Committee. With that, I yield back.
Is there additional discussion on the amendment?
Yeah, Mr. Speaker,
Ranking members recognized.
we can talk about memos. I got a memo here that disproves, basically refutes everything the gentleman just said, but I have a question. When are the transcripts going to be made public and released on the interviews? Does the gentleman know?
That I don't know.
Yeah, okay. Well, maybe before the end of the hearing, he could find out, because again, we talk about open and transparency. That's what we're talking about. I yield back.
Oh, gentlelady from Pennsylvania is recognized.
Sure, I do think it's really important that this process, if it is to go forward, is open and transparent. I've already had personal experience with this process when David Weiss, special counsel, came in, sat for 7 hours of interviews. He offered to testify in public. That offer was rejected. And then we saw members of the judiciary come out and mischaracterize what, in fact, he had said in that interview. Mr. Reschenthaler is absolutely right. The 3 chairs of the committees conducting this sham impeachment inquiry have been all over the news, on Fox, on Newsmax, every night, mischaracterizing what they've found, mischaracterizing what witnesses have said. And that's why it's important that if this is to go forward, the American people be able to judge for themselves. There's a pattern and practice at this point of the Republican majority hiding what's going on, only cherry-picking the evidence that they want to move forward, disregarding when it's contradicted, even by their own witnesses. And I think it's really important that we adopt the gentlewoman from New Mexico's amendment.
Is there further discussion?
Mr.
Chair.
Gentleman from,
Just a quick observation that our Democrat, I'm sorry. Oh, yeah.
gentleman from Texas recognized.
That our Democrat colleagues in the Judiciary Committee, on which I serve, Oversight Committee, I'm informed, are welcome to participate, do participate. Representative Goldman has participated in the proceedings. They're able to see transcripts, they're able to see the information in committees. That stuff has all been transparent and bipartisan within the committees. The timing on how that gets released, that's, up to the committees in that conversation as we go through the continued investigation. But I also noticed we're talking about, people running to the press. Quick Google just shows a week before the presidential debate in 2020, Adam Schiff going on and saying, quote, "While we know that this whole smear on Joe Biden, with respect to the Hunter Biden laptop, I might add, comes from the Kremlin. Clearly, the origins of this whole smear are from the Kremlin, and the president is only too happy to have the Kremlin help and try to amplify it." That's what the American people have seen in terms of show horses going to the TV. I yield back.
Gentleman from Colorado is recognized.
I thank the chairman, and I suppose I'll pose the same question that I posed with respect to the amendment that I offered. I support Ms. Ledger-Fernandez's amendment, and so, for Mr. Roy or for Mr. Massey or any of my friends on the other side of the aisle who care to opine on this, all this amendment does is simply say that the committees, the three committees of jurisdiction that you all have decided are the committees of jurisdiction for purposes of this impeachment inquiry, Ways and Means, Oversight, and Judiciary, that they shall hold public hearings. In prior impeachment inquiry resolutions that have been approved by this Congress on a bipartisan basis, the language has always been shall. The Congress has always decided that when you conduct an impeachment inquiry, that the committees be compelled to hold public hearings, that it's not permissive. Republicans, for some reason, decided to delete that language. The shall language has been deleted from this resolution and instead has been replaced with may, giving your chairman of those three committees the discretion to decide whether or not to hold a public hearing. And so I just don't, and Mr. Norman, if you care to, many of you have spoken in the past about transparency and the need for public disclosure in hearings. And I'm trying to understand why this amendment is objectionable to my colleagues on their side of the aisle, and I've yet to hear a cogent answer as to why that is. And I'm not asking, and Mr. Reschenthaler, if you care to, we can go back in time and you can, go give the litany of examples from 2019. It's a simple question. The 2019 impeachment resolution compelled the committees of jurisdiction to hold public hearings. This resolution doesn't, and I'm just trying to figure out why. And anybody,
Well, I think one thing when you look at the shall and the may language, you got to remember that we're not dictating what the committees are going to do. We're giving them the option to follow the evidence, have the investigation, and then determine whether or not they're going to publish a report at all. We don't think that we should micromanage these committees. As far as the openness and transparency, again, everything has been out in the open and transparent. Going back to the 116th, we have to remember that even after the inquiry vote happened, the Democrats in the committees were still holding hearings in skiffs where you couldn't go out of the room and talk about what was happening, let alone the American people being able to watch. We've been very transparent now in the open. And lastly, if you want to talk about the 116 and go back in time, you got to remember that this committee was given less than 24 hours notice in the 116th of moving forward on the inquiry vote. We've been telegraphing this well in advance. We've been open and transparent, not only with the information, but also with the timing, and I yield back.
So I would just say to the gentleman, again, this is fairly straightforward and pretty simple, okay? The prior resolution, use the 2019 impeachment as an example. The language is this: the chair of the Permanent Select Committee on Intelligence shall designate an open hearing or hearings pursuant to this section, okay? House Republicans replaced the Intel Committee with oversight, understanding that your investigation is being conducted primarily through the Oversight Committee. And you deleted the phrase shall, and instead you put the phrase may. And my point, I don't think it's very complicated. I think most Americans who are watching, by the way, Americans who may agree with you, I think they're a very, very small minority. I think most folks understand that this is a political stunt. But even insofar as, Mr. Norman, you making the case that you believe that there needs to be an investigation, and there need to be public hearings, why delete the language that requires a public hearing? Wouldn't you want a public hearing? I don't understand why you deleted it. I'm going to go to Mr. Norman, because Mr. Reschenthaler, I've given you a couple opportunities. I always enjoy our colloquies, but I'm not getting much of an answer on this one, so maybe Mr. Norman might give me a...
Well, as far as the wordsmithing of it, may or shall, or here's
It's a big difference.
I get that. Here's what's going to happen. The results that's coming out of these committees, I don't dictate when the committees go in and what they do.
You do,
Just
through
like
the resolution.
Donald Trump doesn't dictate what happens. All I know is the results will be transparent, and Ms. Gallen, I agree with you. Let's let the American people judge. And Ms. Ledger-Fernandez, you bring up Hunter's drug issues. Yes, everybody has problems, or a lot of people have gone through the same things. But everybody in America has to pay tax. Everybody has to account for money that they make. Everybody should not get the deal that Hunter Biden was trying to get. And I'll comment, you mentioned that his business associate said that probably the President Biden was talking about the wind and the weather. Here's the testimony from Devin Archer in one of the hearings testified that people would be intimidated to mess with Burisma legally because of the Biden brand. During the transcribed interview with Devin Archer, he described the Biden brand as a value to a company such as Burisma. Question, you keep saying brand, but by brand you mean the Biden family, correct? Archer, correct. Question, and that brand is what, in your opinion, was a majority of what the value that was delivered from Hunter Biden to Burisma? Answer, I didn't say majority, but I wouldn't speculate on percentages. But I do think that was an element of it. Mr. Biggs, when you say Biden family, sorry to cut you in here, I just wanted to get a clarification. You aren't talking about Dr. Jill or anybody else. You're talking about Joe Biden. Is that fair to say? Yes, that's fair to say.
And
That was the answer. I don't know any other clear way to show and to be transparent. This is testimony. And if you go back, Mr. Goose, I mean, all the things that have been found and will, from what I understand, will be found, you can't erase LLCs. You can't erase the pseudonyms that Congressman Roy talked about in the text and emails. You can't erase that. You can't erase the checks. He's got bank statements don't just drop out of the air and you can dispute it. So the transparency, I agree with. The fact of how it's being conducted and what will come out of it, I think the American people will judge. And the Biden family has gotten by long enough on this.
Mr. Norman,
Let's expose it.
I would say,
I yield to you.
and I would say, well,
It's
I'll take back
actually
my.
the gentleman from Colorado's time.
I'm sorry.
But no, that's all right. Look, and I'm going to give my colleague, Ms. Ledger-Fernandez, an opportunity to respond more substantively to some of your comments. But I would just simply say this. You keep on saying the American people have an opportunity to decide. They clearly will not under the process that you've designed. Just so we're clear, absolutely clear. Any Republican that votes for this resolution is voting for a process that would allow the Oversight Committee, the Judiciary Committee, and the Ways and Means Committee to conduct an impeachment inquiry entirely in secret. Entirely in secret. This resolution gives the chairs of those three committees the power to conduct every hearing in private. Every hearing. That's never been done before. The impeachment inquiry resolutions that we've approved, Republicans, have, obviously the vast majority of Republicans opposed them, but nonetheless, the impeachment inquiries that have been adopted have said that those committees shall conduct an open hearing. Doesn't mean every hearing that they conduct has to be in public. That's not what that language requires. It simply requires that they at least conduct a public hearing. And I've yet to hear a cogent answer as to why Republicans want to give that power to their three chairmen to basically say, listen, you know what? Conduct this witch hunt behind closed doors. Do whatever you need to do. You don't need to conduct a single hearing in public for the American people to make up their own judgments. I think that's dangerous, and I don't really understand why. If you disagree with that, you could support this amendment that Ms. Ledger-Fernandez that is offered that literally is 3 words that just strikes the word may and puts shall in place of it, the same way that this has been done since time immemorial on impeachment inquiries.
Will you yield for a
that's all I'd
question?
say. I'll yield for a question.
As one of my colleagues mentioned, I was at the SCIF one time when Adam Schiff was conducting it. We had to basically break in. He had the doors shut. Was that open process in the SCIF?
Yeah.
And with Adam Schiff making all these accusations?
A couple things
Unfounded?
A couple things I would say. So, again, if you're using, let's say, the 2019 impeachment as a template or as a corollary, right? There were interviews that were conducted in classified settings and closed door. There were hearings that were conducted in public, right? We all know that. And Judiciary, I participated in numerous hearings with my colleague, Ms. Reschenthaler, and others in public. There were also interviews that were conducted behind closed doors. So that's not, I'm not making the argument that the entire process is one in which it conducted all through open hearings. All I'm saying is that this resolution doesn't require any of the committees to hold a single public hearing. And I don't really understand why you're so resistant to saying, Chairman Comer, we're going to start this inquiry, and during this process, you have to hold at least one hearing in public. That's a reasonable thing to ask of him. I would think the American people would expect that from Congress. And I'm not, again, I probably belabored this point, but it really is nonsensical to me that Republicans wouldn't just say, yeah, you know what, this is a drafting error. Maybe it was a drafting error on your part, and we're going to include shall, because these committees, when considering something as weighty as impeachment, they should hold at least one of their hearings in public. But the fact that you refuse to tells me it's not a drafting error, and that this was intentional, the same reason you deleted open and transparent from the resolution, that you've decided that you're going to engage in a purely political process. And I think that
Gentlemen, yield.
of course, I would yield to the
Thank you very much. Let me just make a quick point, and I don't usually like to interject myself in debate, but as my friend said, you had open and transparent in the language last time, but not everything was in the open. And I'm not, some of this was classified. I'm not making any accusations of that, but a lot of it was not in the open. In this case, particularly the Ways and Means, may well be dealing with tax returns that would not normally be public. We all know they have the authority to do that. There is some sensitivity about using those words. In the end, we decided we trust the discretion of our chairman. We think they will do open hearings at the appropriate time. But there was some pushback about using this language because there would be times when, frankly, to protect witnesses or folks that accusations might be made, they might be looking at material that you would not, none of us would want shared in the open. So I don't, that may not satisfy my friend, but I just interject that as an explanation as to
I would
what some of
say-
the concern is. And again, I do make the point, and maybe that's just a different thought. We trust the chairman to do the right thing. You maybe had a stronger feeling about, control from the center of it or making certain things. We just don't operate quite that way. Again, we want these committees to operate independently. We trust the chairman to make the appropriate decision. So with that, I yield back to my friend. I thank him for yielding to me.
I thank the chairman, and I'll yield to Ms. Fletcher-Fernandez.
So, thank you very much, Mr. Chairman. And I think that what we are trying to do with this amendment is not require that every single proceeding be open. And I think that's key, so that when there are requirements for privacy, as you've just described, or when there are requirements to protect national security, that can happen. But the idea that there shall be at least some public hearing, because precisely to the point that Mr. Norman is pointing out, that when you are sort of limited to reading through a transcript, you don't get what is very important, which is what about the credibility of the witness? We are going to be asked, and the American people is going to be asked to judge these witnesses on their credibility. And if we could not see them testify before Congress, if we could not see them testify before the committee, we don't know about their credibility. We all know that we get so much of our information as we see each other, as we read each other. That is who we are as human beings, which is why when you are in a courtroom, the credibility of the witness is key, and that cannot be a judge's decision about the credibility of a witness or a jury's decision about the credibility of the witness cannot be appealed, because it is the person who watches that witness testify that makes that decision. And so this amendment that I've proposed allows what you're describing, Mr. Chair, which we recognize is important. It allows it. That's why we didn't say every single thing that these committees do shall be. It says they shall hold public hearings. So it is permissive to allow for the circumstances. And because we think it is so important, we do think it is not something that you leave to the discretion of the chairman, that we say as the Rules Committee, as the United States House of Representatives, undergoing this most solemn, as you described at the beginning, this most solemn of obligation, that we uphold our commitment to the American public, that there shall be public hearings. And that was the intent of the resolution as it was written, precisely to accommodate your concerns. I yield back to my.
Sir, further discussion or debate
well,
on the amendment? Gentleman from Colorado is recognized.
I think the chairman, I would just, and I would echo the comments made by Ms. Ledger-Fernandez. I also want to say thank you to the chairman for providing clarity, at least for me, in terms of some of the rationale behind the selection of the language, because that's really what I was trying to get at and was unable to discern why that decision was made. And what I would simply say is, I think Ms. Ledger-Fernandez captured this right, that the shall language is actually permissive. I think it accomplishes what, Mr. Chairman, you and the relevant committee chairs were seeking to accomplish in terms of requiring a public hearing, but also providing the committees with the ability to conduct the necessary hearings that they believe are necessary in a closed setting. And I would just caution and perhaps, beg your indulgence, Mr. Chairman, as you know, and as Mr. Reschenthaler has made the case before, that, every action we take sets a precedent that then becomes a precedent for future Congresses. And walking away from this shall language, walking away from the open and transparent language, by the way, we didn't do an amendment, but the shall language was removed from the reporting as well. So, that's an important point for Mr. Norman, Mr. Roy, others, for you all to, I'm sure you gleaned this from your review of the resolution, but it's the resolution that, the last impeachment inquiry resolution that was adopted by the Congress had language that requires each of these committees, after they conduct a public hearing, which is required under the prior resolutions, to issue a report, that they shall issue a report. Not the case in your resolution. It's may issue a report. So there's no requirement that any of these committees, after they conduct this impeachment inquiry that you all are very fixated on pursuing, that they issue any report. Not a requirement under the Republican resolution. I'm not sure why. I don't know if that's because you believe if the committees don't find impeachable conduct that you don't want the committees to issue a report that the American people can review for themselves and decide. I can tell you that in prior impeachments, that's been a requirement, so that at the end of the day, the committees can follow the facts, and whether they conclude that there is in fact an impeachable offense or they conclude that there's not, they're required to issue a report by the Congress that they share with the American people. You all have chosen to make that permissive. Excuse me, not permissive. You've chosen to essentially make it an optional for the committees, just like public hearings are now optional for the committees, just like in an open and transparent process is optional for the committees. And so I would simply ask you to reconsider and perhaps give some pause to that. This language here is not, it is not a gotcha. It's just using standard language that's been used time and time before. And with that, I yield back, Mr. Chairman.
Is there any additional discussion or debate on the amendment?
Mr. Chair.
Gentlelady from Minnesota is
Mr.
recognized.
Chair, I yield my time to my colleague from Pennsylvania.
Thanks for yielding me the time. I appreciate it. So to answer my friend from Colorado, look, the reason we have shall instead of may, we got to remember why there was shall language in the 116th. That's because Chairman Schiff wanted to do everything behind closed doors in the SCIF. So Speaker Pelosi had to change the language from may to shall to compel him to have this out in the open. We don't, that's the historical reason why the language was shall instead of may, if you go back to the 116th. We don't have that problem here because we've done everything out in the open. I just read a stat of how many hearings have been public, how many transcripts have been released, et cetera. And then as far as the shall language on issuing a report, we do not dictate a result to the committees that are investigating this. If there's nothing to report, then there's nothing to report. Frankly, you can make an argument that, unlike the Mueller investigation, that airing of dirty laundry shouldn't have happened because there was a decision not to proceed. Now, I think the Democrats have changed the standard, so I like the idea that we do that we do an inquiry and we release everything, whether or not there's a decision to actually impeach or not. Just again, I don't like that standard, but that's a standard that was set by Mueller, and it goes in the face of prosecutorial ethics and ways of conduct. But again, you change the standard, so we should be able to air the dirty laundry. But that's up to the committee chairs. We're not going to dictate to our committee chairs and predetermine an outcome. So that is why there's the difference here, and we're saying may instead of shall. With that, I yield back to the gentlewoman from Minnesota.
Gentlelady yields back. For any further discussion or debate on the amendment? Hearing none, the questions on the amendment, all those in favor signify by saying aye.
Aye.
Those opposed say no. No. The opinion of the chair, the noes have it.
Could I vote, Mr. Chair?
Voted, a roll call has been requested. The clerk will call the roll.
Mr. Burgess. Mr. Burgess, no. Mr. Reschenthaler. Mr. Reschenthaler, no. Mrs. Fishbach. Mrs. Fishbach, no. Mr. Massey. Mr. Massey, no. Mr. Norman. Mr. Norman, no. Mr. Roy. Mr. Roy, no. Mrs. Houchin. Mrs. Houchin, no. Mr. Langworthy. Mr. Langworthy, no. Mr. McGovern. Mr. McGovern, aye. Ms. Scanlon. Ms. Scanlon, aye. Mr. Neguse. Mr. Neguse, aye. Ms. Leisure Fernandez.
Aye.
Ms. Leisure Fernandez, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 9 nays.
And the noes have it. I need to interrupt at this point to advise the committee that the Rules Committee has business on the floor. So we will be recessing and will return at the beginning of the last vote series, after the last vote is cast on the floor, and resume the hearing at that point. So with that, the committee stands in recess.